Carrie Severino joins us, literally wrote the book on these matters, the former clerk for Justice Thomas, Judicial Crisis Network. Carrie, always good to have you. I think the cases that Democrats have been pushing, from which she recused herself, are going to be election-related, not mainly the ACA or related cases. Now, I could be wrong. But in that event, how is that decided? What is the policy or the procedures they go through in the Supreme Court? Do they decide amongst themselves? Does she decide, make the call? Are there rules for this sort of thing?
Yeah, the rules are generally followed with a justice evaluating his or her own recusal, but then also, as Barrett herself pointed out during her confirmation process, in consultation with their colleagues as well. So it's something that she would be discussing with her colleagues in the court. However, I have to point out the historical precedent is really clear on this. Some of these calls for recusal in election-related cases completely foundless, because the historical trajectory is you have the nominees that have sat repeatedly on cases that involve the president that appointed them. Ginsburg and Breyer sat on the Clinton versus Jones case involving the Paula Jones scandal. 3 of Nixon's appointees sat on the U.S. versus Nixon case involving his scandal. So this is one of them recused himself because he was directly involved, because he was the assistant attorney general. So since she has no involvement with this administration, or obviously with the campaign, there's no reason she would have to recuse.
You know, Carrie, while I have you too, much has been made of the fact that it's a 6-3 conservative court now, but we also know that in Chief Justice Roberts, it doesn't always swing to the conservative side. And I'm just wondering, is it actually closer to a 5-4 conservative court? How do you sense the dynamics changing?
Well, I think time is going to tell on this. We're going to know a lot more by the end of this term. Some people have speculated that sometimes the Chief Justice swings because he's trying to avoid these 5-4 decisions, or because he's trying to avoid a political outcome. When he is not the swing vote on that court, we might see that change. I think that would be good, because if he is making those decisions for political rather than legal reasons, that's not appropriate for a judge. So I think if that returns him to making legal analysis the priority, that would be a good thing. At any rate, I think, as you pointed out, it would, at a minimum, I think, with Justice Barrett on the court, now be a 5-4 or 6-3 court in any case, with judges committed to looking at the original understanding of the Constitution and looking at the actual text of the laws as they're written.
All right, but she would, if you had to make a gut call on it, Gary, she would weigh in on election-related issues if they came up. In other words, there are already 200 lawsuits that have been filed ahead of this election. I can't believe it. None of those necessarily get all the way up to the Supreme Court. But I'm just wondering, you don't see anything in her past comments at all that would hint that she would bow out of some of those decisions?
No, that would be totally historically anomalous. I mean, look, Ginsburg and Breyer, for example, sat on Bush versus Gore, and Gore was Clinton's vice president. He's the one who had nominated them. There's no historical precedent for recusing yourselves in election-related cases that have to do with the president that appointed you. It simply doesn't happen.
All right. Carrie, thank you so much.